Ready? Start. In the instant appeal, the appellant is challenging the order dated 6/10/2025 passed by the High Court of Madhya Pradesh in miscellaneous criminal case number 22396 of 2025, whereby the High Court has rejected his regular bail application filed under Section 483 of the Bharatiya Nagarik Suraksha Sanhita, 2023, in connection with FIR number 105 of 2025, registered at Police Station Shahpura, District Bhopal, Madhya Pradesh, for the offence punishable under Section 108 of the Bharatiya Nyaya Sanhita, 2023. However, subsequently, a charge sheet has been filed for the offences punishable under Sections 108 and 80 of the BNS and Sections 3 and 4 of the Dowry Prohibition Act, according to the appellant, when on the morning of 21/3/2025, the deceased did not come out of her room, the appellant got worried and knocked on the door and called her several times, but the door was locked from inside, which was ultimately broken, and the appellant entered the room in the presence of some individuals who were present with the appellant when the door was broken. The appellant found his wife lying on the bed in an unresponsive state. There were needle pricks on the left hand of the deceased. The local police was informed, and the family members and relatives of the deceased were also informed. She was taken to the hospital in the presence and in the car belonging to the uncle and aunt of the deceased. Upon reaching the hospital, she was declared dead. In the FIR lodged by Himanshu Pandey, he was prima facie suspected that the deceased committed suicide due to persistent mental harassment inflicted upon her by her husband, Dr. Abhijit Pandey, as he was having relationship with his nurse Mahi. It was registered for an offence relating to abatement to commit suicide. No allegation of demand of dowry was made in the FIR. The counter affidavit filed by the state contains the first case diary statement of Vinod Chandra, in which there is no allegation of demand of dowry. Considering that the FIR was registered for an offence concerning abatement to commit suicide, and the deceased had not sustained any such injury which can be said to be the cause of her death, and prima facie it is found that she died, which is a medical given as anesthesia, and the deceased herself was an anesthetist, and that the allegation of demand of dowry was not made in the first instance but was made in the subsequent case diary statements, as also for the reason that the appellant is not a hardened criminal, though one more case is registered against him concerning cheating and forgery, in which a large number of persons are involved, and there being no possibility of the appellant not being available for trial, as also for the reason that he is in jail since 25/3/2025, we are inclined to allow the present appeal and release the appellant on bail. The appeal is allowed. The impugned order dated 6/10/2025 passed by the High Court is set aside.